Perfect. Can everyone hear me? I hope so. Thank you so much, Ala, for that introduction. Hi, everyone. My name is Nicholas Hawkins. I'm an attorney at Womble Dickinson. We are an international law firm specializing in, if you name it. We have everything from intellectual property to transactional work on that side to also litigation, everything. So personally, I work mostly with intellectual property and what we call soft IP. So that's your trademarks, your copyrights, your trade secrets. Also do advertising law, a lot of media. I also work with our corporate and securities group, doing a lot with venture capital financing, private equity, corporate governance, and that sort of thing. But today we're going to talk about IP strategies and how to protect and commercialize your intellectual property. As Ala said, if you have any questions on the presentation, this is my first Zoom cast, so I'm getting used to it myself. But feel free to just chat me or chat everyone, as Ala said, and we'll answer those questions in a timely fashion. If it's something that you think that can wait till the end, you'd like to ask via turning your mic on, that's fine as well, whatever works. All right, let's get started. Okay, so today we're going to talk about a few things. One, I do believe that there was a session yesterday on basic IP. I'm going to go over some of that today because it lays a foundation for what we're going to talk about. But then we're going to get into IP strategy, talk about a few things for building your strategy and creating a successful strategy. And then we'll get into IP commercialization. So that really is, how do we make money with our IP? All right, so first, IP overview. And again, as you might have attended last night's session, I'm just going to do this to lay a foundation. But we have 4 different types of IP, right? We have copyrights, trademarks, trade secrets, and patents. Sometimes people like to slip domain names into that group, whereas domain name is not actually an IP. It is what we like to call part of our intellectual property portfolio, maybe, or our intangible asset portfolio. Right, so copyrights include any expressions of ideas, with books, articles, software, music, art, etc. And they attach immediately. Okay, what that means is that if they are what we call fixed in a tangible medium of expression, all right, then that means that you have a copyright as soon as it's created. You can also register your copyright, and registering your copyright gives you certain statutory rights for that piece of intellectual property. That includes things like statutory damages if someone were to infringe your copyright. Copyright lasts a long time, 70 years from the author's death, right? So it includes the life of the author plus 70 years after that. Trademarks. Trademarks are source identifiers. They're marks, symbols, words, even colors and sounds can act as trademarks as long as they identify the source of the good or service. Government grants registrations to trademarks, but you can also have something called a common law or state trademark. That is a trademark that is used in a state or certain states, but does not have federal registration. Okay, for federal trademarks, the term is 10 years, but that term is renewable. So as long as you continue to use the mark for that good or service in commerce, you could potentially have an indefinite rights to that trademark. I also included trade dress in here because it's important to note that, well, trademarks are source identifiers for marks and symbols. Trade dress acts as the same, but it's, if you kind of think of a product, for instance, like a Coca-Cola bottle, right? When people see a Coca-Cola bottle, they automatically know that, well, that belongs to Coke, right? That is a form of trade dress, and trademarks and trade dresses fit within the same category. Next, we have trade secrets, and trade secrets are tricky because there are there's no formal way to protect a trade secret except by keeping it secret, right? And so how do we do that? Well, we do that through confidentiality agreements and other means to make sure that our trade secret doesn't get out. Okay, so we talked about a Coke bottle before. Let's talk about Coke's secret recipe, right? No one knows what that is, right? They keep it under lock and key, right? They make sure that they take efforts to control who gets to see the secret sauce, who has access to the secret sauce. Their distributors, their manufacturers, I'm sure have confidentiality agreements, which make sure that no one can see the secret sauce. So there are ways to protect the trade secret and make sure that it doesn't get disclosed. And for patents, the last form of intellectual property, therefore any new and non-obvious device, systems, compounds, any materials, methods, but it has to be new, right? It cannot be anything that is, it cannot be an abstract idea, or cannot be something that is found in nature, right? And government grants patent rights, and they are effective 20 years from the effective filing date. If anyone has any questions for just basic IP, feel free to ask that as well. I'm happy to answer. All right, so let's talk about IP overview and developing a strategy, right? So we know now what a copyright, trademark, patent, and trade secret is, but then how do we identify those things in our own companies, right? So when we think about it, we have your brand, right? What is your brand? Your brand could be a logo. It could be the name of your company, right? It could be the name of a certain drug that you're creating. It could be the name of a certain product that you're creating. It could be the name of a certain service, right? So how do we protect the brand? Well, we protect that through trademarks. We protect that through the contracts that we have with third parties, right? One of the things that I think about are brand guidelines, right? So when you create a product or a service and you allow someone else to use that product or service, you want to make sure that they're using it in a way that is consistent with your guidelines, right? Make sure that the mark and logo is seen a certain way so that consumers can identify that easily, right? You might have products or services, and how do we protect those? We protect those through trademarks again, right? Through the copyright. Sometimes the design of the product or service might be copyright, right? If you have any computer code, you can protect that through copyright, right? Some aspects of the products might be patentable. You can protect that through patents, right? And again, trade secrets, right? Those things that are secret to our product or to our service that we want to keep under wraps, right? We might look to trade secrets and confidentiality agreements to protect those. Your business models and transactions, again, how do you protect those? Well, through trademarks, through all four, right? Trademarks, trade secrets, contracts, and sometimes even patents. And your employees and your own research, right? How do you protect the sweat that we've developed over the years and many of our beloved companies? Well, through contracts, right? Through making sure that the people that we let into our circles understand that what we're providing for them is confidential, right? So we protect those through contracts. Even sometimes copyrights might be to protect our research. If we file federal registration for our research, we can protect it under copyright. All right, so now we have a basic understanding of how we can protect the different things that we've created. Let's talk about developing the strategy to protect this. All right, so the first thing that we want to do is we want to conduct an investigation. We want to figure out what we have, okay? And if you don't know what you have, you're not able to protect it and develop a successful strategy, right? Now, how do you do this? Well, if you are a company that has developed, we used the drug analogy before, so developing certain drugs or chemical compounds or things of that sort, if you created a name for that drug, right? Well, we know that we need a trademark, right? If we know that we've created a specific type of composition of matters or compounds for that specific drug, we know that we will probably need a patent, right? Or maybe there's something that we've created that we don't want to share with anyone, right? So maybe we have a trade secret, right? So we protect that through confidentiality agreements, right? And maybe our product or our IP includes artwork or music or things of that sort, or computer code. Again, well, we know we need copyrights, right? So your first step is finding out exactly, taking a look at your business, your products, and your services, and figuring out, what do I currently have? What do I own? And figure out, how do we handle it now? Meaning, do we have protection for these goods or services or products or IP? Is that something that we can get easily? Do we need to engage other colleagues or professional service providers such as lawyers to kind of help us think this through? The first step is figuring out what we have, because again, you can't protect it unless you know exactly what it is that you have. All right. And so the second part, I kind of led into this already, but you should figure out what out of what we have already needs to be protected, and what is our budget for protecting it, right? So if anybody knows anything about patents, patents are very expensive. They can get very expensive. We're talking tens of thousands of dollars many times, right? And you may not be able to protect everything right now, given financial constraints or other things that are going on, and that's okay, right? Your job right now is to develop a strategy, which means that sometimes you'll have to prioritize what needs to be protected right now and what can wait a little bit down the road to be protected, right? Sometimes we think about what are our interactions with third parties, right? If we have a potential licensee knocking on our door to license our product from us, well, we know that we need to get things like our patents and our trademarks taken care of first before we can license those rights to a third party, right? So this process helps us understand exactly what we need to protect going forward. Third, after you've figured out what it is that we need to protect, you think about how you can develop that and implement it into a business strategy, right? So that's something that you think about for right now and something going down the future, all right? So what IP do we need to develop to defend our current revenue streams, right? So if we have created a certain product and we know that we are selling that product and we know that that product includes certain proprietary rights, then we know that there's certain things that we need to protect in that product. And then lastly, we want to build a program around that strategy. We talked about budget before, but we want to think about budget moving forward, right? What kind of dollars do we need to put behind that? What kind of financing do we look for to begin to build and protect our strategy? We also want to make sure that the people that we bring on board understand the purpose and the importance of developing IP, right? Some companies might be very heavy in IP and others may not be, and that's okay. But bringing people on board and training them to be able to look for different types of intellectual property, being able to recognize intellectual property and have an appetite to protect it is very important, right? So we want to train our people to do those things. We want to train our people to be able to identify a trademark, to identify a copyright, okay? Identify a patent. We want to make sure that they have signed the confidentiality non-disclosure agreement, so they're not going off and telling other people about what we have to be protected in our companies, right? That's really important. All right, so a successful IP protection strategy, we talked about patents, trademarks, copyrights, and trade secrets, but you may not need them all, right? Think about it. If you are developing, I'm just gonna make a analogy here. So if you're developing a new vacuum cleaner, for instance, right? You might have a patent in the motor, for instance, right? You might have a patent in, I don't know, the way that it sucks the dirt from the carpet, right? You may have a trademark in its name, right? You may not have a trade secret though for a vacuum cleaner, right? You may not have certain copyright protection that you need in the vacuum cleaner, right? Whereas if you're developing a new drug, for instance, well, you may have certain patentable aspects in the composition of matter, right, for that particular drug. You might have trademark protection for the name of the drug, right? You might even down the road have some trade dress protection for the color of the particular drug or the way or the shape of the drug, you know? So just start thinking about this. You don't need them all necessarily, right? But if you're able to identify what you need, you're able to protect it early on, right? And again, I can't harp on this enough, but you need to build your IP strategy around your business needs and the priorities of your company right now, but also thinking about the future, right? And so how do we do this? Well, we have to practice good IP hygiene. What does that mean, right? And these are things that you can do even right now. I'm going to create a list of all of your IP assets, all right? And create a chart. You have copyrights, trademarks, trade secrets, and patents, right? And your goal is not to fill them all in. If you take a look at your company, take a look at your products or services, and you realize that, you know what, Nick, I don't have any copyrights, right? That is okay. Or I don't think that anything that I have could be copyrighted. That is okay, right? But I would also actually take a step further too. Ask other people in your company, right? Ask your colleagues, right? Do you think I could protect this? And if so, somehow. Ask attorneys, right? I get emails all the time from founders of companies, and I'm happy to have that conversation with them, right? You know, let's talk about what you have so that you can protect it. You also want to actually protect this list, and I put this in here, understanding that nowadays, you know, anything that you put on a computer can be easily hacked. Even this Zoom, unfortunately, can be easily hacked, but thank you, Allah, for keeping us all safe. So you want to protect this list that you create as well, right? If that list has any patent claims or trade secrets on there, you want to make sure that that's protected. Does that mean that you should create a physical copy and keep it under lock and key? Maybe. I don't have the answer for you for that. But whatever you do, you want to protect that list as well, right? You also want to protect who has access to that list. But I will tell you this list is a good resource when it comes time for investors to kind of take a look at what you have. Investors want to see that you've already taken the step, right, to practice good IP hygiene, to create a list of your IP assets, right? Next thing is you want to resolve any issues of ownership. We could probably spend an entire lecture on ownership, but a lot of times founders, when they create something, they want to own it outright, which is fine, right? Or sometimes maybe there are two founders that have created something and they want to own it. That might be okay, right? And there might be, perhaps you've tapped a coder to develop some code for your company, right? Should they own it, right? I would argue that probably the company should own any IP that is created, right? And there are different fact patterns and reasons why that might be good, may not be good, but generally you want to think about who should own the IP. And if it is a situation where you brought in a code or you brought in another third party to create something for you, right? You want to make sure that you have agreements with that party, right? That anything that they've created belongs to the company. You don't want to get into a situation down the road where you are arguing 1 or 2 years down, who has ownership rights to a particular part of IP, especially when investors come on board. The next thing you want to do is understand any requirements for maintaining IP protection and deadlines, right? Unfortunately, this is a housekeeping thing that many times we have document systems to make sure that our clients know any deadlines for any type of intellectual property. We also want to make sure that you are aware of these deadlines as well, right? So for instance, for trademarks, anytime that you have a registered trademark, you have between the 5th and 6th year what we call file a statement of use to make sure that you're using that trademark, right? And if you don't file this, you could lose your rights, even though trademark protection is for 10 years, right? There might be similar deadlines for patents as well, right? So you just want to make sure that you've docketed and have a clear understanding of any deadlines that are necessary. I put in here in parens the confidentiality for trademark secrets. It's important for a trademark, for a trade secret, they maintain confidentiality. That's what protects a trade secret, right? And how do you do that? Again, through confidentiality and non-disclosure agreements. So by doing these three things, by practicing good IP hygiene, we make sure that we've maintained and protected this IP strategy that we've created and that we spent so much time on. Now, there's a question for maybe why do we want to even worry about this? Why is this an issue, right? Why do we spend money and time on IP development? Well, a few things. From a risk management perspective, developing a strategy helps us weather the storms, right? What does that mean? If someone comes along and says, I notice that you're using XYZ in your product, right? We actually have a patent on this, you could be in a position where you're like, oh my goodness, this is crazy. Like, what do we do now? But if you already know what you have, right? If you've already done your due diligence, and we'll talk about that a little later, then you know exactly what claims that you have in your own product, right? And so you can answer that, and you can answer that potential infringement, right? And move down the road, right? It helps prepare us and manage attacks. Same thing, right? It can be used as a sword or a shield against competitors. What do I mean? Well, again, if someone were to come after you and say that you're infringing their patent, their trademark, their copyright, you can have a true answer on how to respond to them because you've done your due diligence. At the same time, developing a strategy allows you to go after potential infringers, right? Think about it from a trademark point of view. Right? If you develop a drug name, for instance, and you have registered that trademark, and then someone else down the road develops that, you're able to go after them for potential IP infringement, for trademark infringement, right? Other reasons why we want to spend time and money on IP development: it increases our revenues and profits, right? Effective branding can improve profitability, right? We think about the mega brands of today, right? Your McDonald's, your Nikes, right? A lot of the car companies, right? They have strong brands, right? And many times those brands are associated with different efficiencies for the business, right? Or if you know that you go to McDonald's, maybe not now, but that it was good food, right? You get a certain feeling, right? You know that if you go to Nike, you're getting a certain level of product, right? And that's important, right? So having an effective brand can lead to prize that you never considered when you engage in this process, right? A lot of times when we think that we have something, right, we don't really even realize that we have something totally different, or we have even more. We begin in this process of understanding your intellectual property portfolio, you start to realize that, you know, oh, wait, maybe I do have copyrights. I didn't understand that. I didn't see that before, right? Or I didn't realize I could patent this part of this product, right? And a lot of times what the founders will do is we'll engage lawyers and other third-party providers to help us see this, right? And sometimes you can't see it. Sometimes you have to reach outside or ask, you know, your co-founders or your colleagues again, and kind of see, okay, what do I have here? How do you think I can protect this? Right? So going through this process allows us to see business opportunities that, again, you may not have considered. And I've said this before, and I'll just say it again, is that developing an IP portfolio and strategy, it improves our business valuations, right? Lenders and investors like to see IP assets that are protected, right? That you have a list and you are sure you know what you have will knock a lot of investors off their feet. A lot of founders don't go through this process, right? A lot of them don't take the time to go through and develop a strategy for how to protect, right? I was talking to a young founder not too long ago, and they have developed an app, right? And I was talking to them, and they had one trademark for specific business services for this app. And I told them, I said, well, have you thought about filing a trademark for the same name in a different service category, and it fit within it. And they were like, no, I hadn't thought about that. And I said, well, you're actually using it for these other types of services as well, but you've only protected it for this, right? And lo and behold, they wound up filing a few more trademark applications for those other services. And this is important, right? This is what we talk about when we talk about building an IP portfolio, right? It's about bringing people in who understand the landscape and help you develop and protect your assets, right? Before I go into the next part of the presentation, I want to pause there, Ala, and just ask if anyone has any questions about basic IP strategy development. The next part we're going to do is talk about commercialization of IP. So I'll just wait a few seconds and see if anyone has any questions. All right, no questions. And again, feel free, even if it's for the first part of this presentation, feel free to ask. In the second part, I'll be happy to answer. All right, now we're going to talk about IP commercialization. And what does that mean? Well, it means taking all of that strategy, all of that IP that we talked about in the first part, right, and trying to make money off of it, right? What is the next step, right? We're bringing it to market. How do we do that? Well, there are a few different ways that we can do this, right? First, there's an internal process for getting our IP ready for the market, right? We can do it through sales. We can do it through licensing. We can do it through consulting, and we'll talk about each one of these separately and also do a couple case scenarios at the end. I see that I have a chat question. Thank you, Hemi. Are there any other ways to protect branding? I think there might have been another question. Hemi, I think there might have been another question above that. I'm not sure, but to answer your question about branding, yes, you protect branding through trademarks, right? Think about the brand. The brand consists of many things. It consists of the name. It can consist of the logo. We talked about colors and sounds before. It was a little more complicated, but Let's talk about logos and words. You protect those through trademarks. So if you have a name, a product name or name of service, that can be protected, right? This is different than your business name, okay? And this gets kind of cloudy, so bear with me 1 second, right? So if I have a company called ABC Incorporated, right? So that's ABC, comma, Inc., period, right? That is a business name, all right? Can you trademark that business name? Technically, yes, but it has to act as the source of any products or services. That means that if you have any products or services under ABC Inc., then those products or services have to be ABC Inc. products or services. Usually people don't do that, right? There's specific reasons why business names aren't generally considered as trademarks, right? So then therefore, if I have ABC Inc. as the business name, but I have ABC as a product name, right? Your product name will be able to be trademarked, right? Now, what about domain names? Domain names are a big part of our branding as well, right? And I talked about that at the beginning. While not particularly IP, intellectual property, it is part of our intangible asset portfolio, right? And courts and for many other reasons have found that domain names on their own are not what we call distinct to serve as trademarks. However, we think of, what's a good one? Hotels.com, right? There's actually a litigation about that. That's probably not a good idea. But there are other domain names that might serve as trademarks because they're being used in the marketing, right, for the product or service alongside with that product or services, right? So it's just not the domain name itself, right? 1-800-flowers, 1-800-flowers.com, right? Is a good example, right? So there's a registration for that because everywhere you see it's 1-800-flowers.com, right? And that is acting as a source identifier. So to answer your question, the way to protect branding is generally through trademarks. And again, we talked about trade dress a little bit before, but your trademark category is how you protect branding. I hope that helps. I mean, if you have any other questions, feel free to ask. All right. So let's talk about eternal ways to commercialize our IP, right? Well, we spent a good 20 minutes before talking about creating an IP strategy, right? And this is really the first step to commercializing your IP. You want to know, again, I'm not going to harp on it enough today, is you want to know what it is that you have. What have you created? What type of intellectual property do you have, right? And this involves a few other things too. One thing that we didn't talk about, and I'm not quite sure if it was talked about yesterday during the general IP overview, but creating or conducting a freedom to operate analysis. What does that mean? Well, it's basically your due diligence on patent claims, right? So if I have a certain product that I've created, right, or again, certain business process or compound or machine or some item of manufacture or something, and I'm not quite sure if I can get a patent on it, right? But I'm also not quite sure if this infringes any other third party's patents, right? I want to do due diligence on that product, right? So that we call it a freedom to operate analysis, right? And that is something that you can engage a firm to do for you. You can they'll do patent searches, and basically this is a way to make sure that you're not infringing any type of patent claims from third parties. How can you do this internally as well? Well, proof of concept, right? And prototypes. These are two different things, right? Proof of concept is making sure that our thing works, right? We're proving a concept, right? Our prototype is taking that a step further, right? After we figure it out if it works or not, we create a prototype, right? And sometimes we create a prototype alongside with a proof of concept phase, right? But these are ways that we developed our IP in order to commercialize it, right? The advantages of this, well, again, it helps determine what can be commercialized and what can't be. Disadvantages, we can get stuck in this internal process, right? We can get stuck in the testing and the concept phase, right? And never get out to the next phase, which is the sales and licensing and consulting phase, right? It's also important to realize that at some point of our companies, we're going to kind of always be in this internal phase. You're going to always be doing freedom to operate analysis. You're always going to be doing proof of concept analysis on certain aspects of your products or services, right? That maybe haven't made it to market yet, right? This is part of research and development of any company, right? But if you think about it like a funnel, right? Everything comes into the top, and we want to get it funneled down through to a few products or services that have been proven, so that we can be able to take the next step in commercializing our IP, our products or our services, right? But how do we protect ourselves in this process? Well, we do it through NDAs and confidentiality agreements. I mean, at this phase, it's mostly internal, right? So we want to make sure that anybody who's working on our testing with us, our product with us, or our service with us, has signed confidentiality and non-disclosure agreements with us. That's what an NDA is, a non-disclosure agreements, meaning that they won't disclose anything that they're doing or that they found or any research to third parties, right? Confidentiality agreements mean that we keep these things confidential, right? Through proper IP hygiene, we talked about this before, right? Make sure that you understand what it is from an IP perspective that you have. Make sure that it's all protected, right? Through proper company hygiene, this is something that we haven't talked about, but something that we could probably spend another webinar on for sure. But that is that certain company structures, right? Whether it's in limited liability company or a corporation, have requirements for maintaining those entities, right? An investor is going to want to see that, you know, have you held board meetings, right? Have you taken meeting minutes, right? Have you, if there was an amendment that needed to be made, did you file the amendment with the necessary state department, right? Whether it's in Delaware or here in Maryland or some other state, right? So you're going to want to make sure that you also follow proper company hygiene as well as proper IP hygiene. And again, company hygiene, we could take another session on that, but if you have any questions on what that means a little deeper, I'm happy to answer any of those questions. All right, so for sales, what does that mean? Well, we can sell our products or service. It's pretty straightforward, right? So how do we monetize that? Well, we do mass production and mass distribution of our product or service, right? And many sales equals more money most of the time. What is the disadvantage of this? There's a loss of control, right? Whenever you sell something, you no longer have control over that thing that you've sold, right? Think about a vacuum cleaner again. When I go to Target and I buy a vacuum cleaner, let's say, you know, I'm buying that vacuum cleaner and I can use it to vacuum my house. I could also use it to take it apart and create some kind of world-destroying robot, right? Whatever I want to do with that vacuum cleaner, I can do, right? Because I purchased the vacuum cleaner, right? Well, what about something like software? You know, when I buy software, do I have the ability to kind of do whatever I want with that software? We'll talk about that next, but we'll figure out that software doesn't actually fit within the typical sales concept. How do you protect yourself in a sales environment? Well, through your manufacturing and distribution agreements that you have with your third parties, right? And there are certain things that should go into these agreements that protect you as the owner of the product that you've created. We're going to watch for what we call dilution with co-branding, all right? Now, dilution has a very specific definition in trademark terms. But what I'm talking about here is you want to make sure that the brand that you've created is strong when it's put up against another brand, right? So if you're selling something to a third party, right? Let's use our vacuum cleaner analogy again. And I'm selling vacuum cleaners at Target, let's say. So, right, so I'm producing vacuum cleaners and I have an agreement with Target to distribute my vacuum cleaners, right? I want to make sure that my name for my vacuum cleaners, let's call it a Hawkins vacuum for many reasons. Let's just say that can be trademarked, right? Hawkins vacuum, right? I want to make sure that that brand, that logo, right, is not somehow maybe incorporated into the Target brand, right? I want to make sure that those are two distinct separate brands, right? Prior to working at a law firm, I was in-house counsel for an apparel company, and there are many opportunities to co-brand in apparel, as I'm sure you're aware. And a lot of times things came across my desk when these co-branding opportunities occurred for what we call marks within marks, right? So it would be the company that I work for's logo, right, within another logo, right? And as legal counsel for the company, my advice would always be, you want to make sure that, you're not diluting the brand, right? that this connection, this junction of logos, right, should make sure that people understand that they're two separate brands that have come together, right? That it's not one full brand, right? So that's what I mean by watch for dilution with co-branding. Now, what about the sale of my IP, right? This is a little different than a sale of a product or service, right? What if someone comes and taps you and said that, hey, I want to buy this patent from you, right? I want to buy this trademark from you. I want to buy this copyright. In the IP world, we call this actually an assignment, all right? Think about for a car, for instance, this is a good analogy, right? When you buy the car, you also buy the title to the car, right? Someone assigns the title over to you. This is a one-time sale, right? Same thing for a product or service, right? When you sell something, it's out of your control, right? And I think a lot of people realize this, but when you sell something, you have total relinquishment of IP rights, right? You give someone else the right to your intellectual property. One of the things that we have to think about when we sell IP, though, is what is the fair market value of that IP? And there are many law firms and accounting firms that will help you value the IP, especially when it comes time for investors or something. But that's something to think about. Like, what is the fair market value of the IP that I have now, right? You also want to think about what is that future value when it's being sold to perhaps a company that can take it a step further, right? So there's things to think about when someone wants to buy your IP. Licensing, okay? How do we do this? Well, let's use our software example again, right? So when I buy, let's say, like Adobe software, right? Of course, I'm purchasing the software, but what I really get is a license. Okay? I get a license to use the Adobe software and anything else that comes along with that license, right? The advantage of this is that Adobe still has control over how it's distributed. They have control over what I can see, what I can't see in that license. They have control over what I can do, what I can't do with that license, right? Many times for licensing, in some cases, it might be better than a sale, right? You think about a sale as a one-time thing where you get a certain amount of money for your product or service or for your IP. But for licensing, a lot of times what we have is what we call licensing royalties, right? So you get paid over time, or maybe you get paid upon a certain amount of sales, right, of the product, okay? Or maybe you get paid during certain milestones or during certain metrics, right? So sometimes licensing may look a little more better than selling outright your IP, right? Now, what are the disadvantages? Well, the terms matter. We'll talk about this a little later, but if you have an exclusive license with somebody, that might be a great thing, right? It might be a really great thing, but it also means that it's exclusive to that third party, right? So what about non-exclusive licenses? Well, that's great too, but if you have non-exclusive licenses, that means if someone comes along and has this really unique opportunity, you can no longer, you can't just give them an exclusive license because you're already giving other people non-exclusive licenses, right? There's some things to think about, right? Then others are good or bad per se, right? I don't have the answer for everyone's fact patterns because I don't know them, right? So you just have to figure out how it fits squarely within your strategy. So how do we protect ourselves? Well, just like sales, we protect ourselves through manufacturing, distribution, and co-branding agreements, right? We protect ourselves through confidentiality agreements, especially with trade secrets, right? Through all of these agreements, right, some things that are very important, right? The price, the scope of the agreement, right? What it is that we're licensing. Are we licensing the entire patent? Are we licensing the entire trademark, right? Are we licensing a trademark in a certain form or fashion, right? What is the geographic region? What is the geographic region that we are licensing, right? Is it the entire United States, the entire world, right? Is it a certain territory? What is the term of the license, right? Do we want to set it for 1 year that's renewable, right? Or do we want to do it 1 year that's negotiable among the parties afterwards, right? And how do we terminate that, right? And I'm going to bring it back to branding because there was a question about it earlier. From a branding perspective, right? If I license my brand to a third party to use, right? But they use the brand in ways that I'm not okay with, then I want to make sure that I can terminate that license, right? So you want to make sure that you have those kind of clauses in all of these different kinds of agreements. And we talked about exclusive versus non-exclusive before, but again, just to harp on it, if you have an exclusive agreement with somebody for one particular thing, then you cannot also have a non-exclusive agreement with somebody else for that same thing. Okay, so just think about how that works within your strategy. Next is consulting, right? And consulting is a little different than both of these, because consulting, it takes your knowledge and your experiences, right, and applies them to other third parties, right? And so how do we do this, right? So we do this through non-disclosure agreements. We do this through confidentiality agreements, right? Now, if I'm consulting for a third party and I have some ideas that I brought to the table, and they use those ideas and create IP from that, you know, is that jointly created? Should my company that I consult under have access and rights to use that IP? Well, maybe, right? And so you need to figure out how that works within your strategy if you're consulting for a third party, and ownership issues that we talked about before, right? All right, so we went through internal ways to prepare for commercialization. We talked about sales and licensing and briefly consulting. Let's look at this in practice briefly, right? So software, we talked about how it really fits into a licensing model because you're not purchasing the software outright as an end consumer. But what if I was a business, right? Maybe you would sell your software to me as a business, right? So then I can have access and do whatever I want to do with that software, right? That's a little different than selling to end consumer, right? And I could do this through consulting as well. If you think about it, for Adobe or Microsoft or any kind of SAP or any kind of third party that has software for companies, businesses, and end users to use, they all have packages for service, for maintenance, right, for customization at the end, right? Whenever you go to the Apple store and you buy an iPhone, you can always buy that Apple, was it Apple Care, I think, for 2 years afterwards, right? So it's building in a service and maintenance mechanism into the product, right? Which includes software, right? Which includes patents, which includes trademarks, which includes trade dress, right? So just trying to see how all these things work together. Like your product can have all of these different parts of IP that you created through your strategy, and now we're figuring out ways to monetize, right, on that strategy, on the different parts of IP that you've created. All right, let's look at it from a bio or pharma perspective, right? So from a sales, you could sell the drug, right? You could sell the actual product, right? You figure out the treatment. You can sell the treatment, right? Or develop the treatment and sell that, right? It's a one-time sale, right? So you could sell the drug to a third party, to big pharma, and you know, we've created this. We want to sell it to you for X amount of dollars, right? And with that comes all rights and responsibilities and so on and so forth, right? But we could also be in control of that process and license it to a distributor, right? Right? We would license those patents to a third party so that they would be the ones who would help us monetize that IP, right? And consulting being that area which is your own kind of knowledge and expertise, you can conduct seminars and training and development in the health industry, right? Showing that you are experts in this field, which attracts more people to your research, to the products and services that you offer. It also looks really good from an investor point of view as well. So one of the things that I wanted to briefly talk about after we talked about IP strategies and commercialization are the business structures that are needed to make sure this happens. And when I say business structures, I actually mean corporations, limited liability companies, holding companies, all of that. Things that maybe some of you aren't quite thinking about now, but just something to kind of think about for the future, right? You want to create business structures and relationships that provide for flexibility. What do I mean for that? From a financing perspective, right? Many times, a lot of, especially venture firms, want to see companies and not limited liability companies, right? I mean, corporations and limited liability companies. Why? Because that adds flexibility from a financing perspective, right? You want a certain type of business structure that allows attraction and retention for personnel, right? So people that you want to bring on board, right? You want to pick a business structure that allows for control, whether or not that's for you and a co-founder, right? For you and probably maybe an investor, an early investor who comes on board, right? You want to find a business structure that is appropriate for both profit and growth of your company, right? And one of the things I always tell people is that I don't have the answer unless I know your specific industry or know your specific fact pattern, right? So each one is different, right? So I can't give an overall, like you should do X, you should do Y. For each one of you on this call today, it might be a little different, right? So it's important to kind of figure out what works best for your company, which works best for your IP and the products and services that you've created. You want to create business structures and relationships that provide protection for the intellectual property, right? If I today were to create a company, right? Not even create a company, let's just say that. Let's just say I create a product, right? And I do it as a sole proprietor. Well, there might be issues with that, right? If, for instance, my product infringes a third party and I haven't created an entity that owns the IP to shield behind personally from a liability perspective, right? So you want to think about that. You want to think about protection for executives, right? For you as the founder, for maybe a co-founder, right? What does that look like in a partnership perspective, right? You want to create protection for your income stream and for a tax point of view. We talked about, whether that is you should treat the corporation as a pass-through entity, whether that should be a C Corp. Those are all considerations that should be had, right? Create various entities that suit your needs, right? So if your company holds all of the IP assets, right, that could be a good thing, right? Maybe you should create, though, a holding company to hold the IP assets in case you want to bring someone else on board to the company that shouldn't have access to or any rights to ownership of the IP, right? And again, I don't have the answers. There's some things to think about, right? Maybe you want to create a different arm of the company that's a licensing branch, right? That takes care of all the licensing with other third parties, right? Maybe you want to create a different arm of the company that's a distribution or manufacturing vehicle, or another arm that handles all the consulting that you're going to do from on the side, right? These are just some things to think about, and many lawyers, especially tax lawyers, can help you think these things through because a lot of them have tax and income consequences. Ooh, document considerations. All right, so one of the things I always tell founders is that you need to document and paper everything, right? Any kind of relationship that you have with anyone that's brought into your company, into your circle, needs to be documented. Why? Because when things hit the fan and aren't looking so good, right, and fingers start to get pointed, you want to have a document to go to, right? That specifically lays out the obligations and the rights of each of the parties, right? And these are a lot of times listed in employment or contractor agreements, right? When I have IP licensing agreements to third parties, right? Never give somebody the right to use your trademark, right? To use your copyright, for instance, without having a licensing agreement, or definitely not without your patent. Confidentiality and non-disclosure agreements, we talked about these ad nauseum, right? Like making sure that the people that work with you and for you have signed confidentiality and NDA agreements, right? And marketing agreements, what are these? Well, I kind of mentioned this before, but brand guidelines, right? How your brand should be displayed and shared with other third parties, right? You want to just take some time to create those guidelines so that you know that when a third party is using your marks out there in advertising, that they're using them correctly and appropriately. All right, this is my last slide. We have about 10 minutes for questions after this, but I wanted to wrap it up and just kind of talk about what we discussed today, right? So you want to first develop a strong IP strategy, right? That's recognizing your copyrights, trademarks, patents, and trade secrets. And you want to make sure that you bring people on board that can help you through this process, through this discovery process, right? You want to determine the best ways to commercialize your products, services, and overall IP, right? Whether that's, well, it is starting in the internal process, but then whether that's in sales, licensing, or consulting. And there are two that I didn't mention, but joint ventures and partnerships, right? that is another way to commercialize your IP, right? Developing relationships with other companies, with other brands that will help push even your research forward, to help push your products and services and your IP forward and make your portfolio more robust. You're going to find a business structure that works best for achieving the company's goals and serves the IP needs of the company. Again, we could spend a lot more time on this, and I kind of brushed over it, but there are ways and there are lawyers that can help figure out what is the best structure for your company and your IP goals, right? And lastly, I can't stress the harp on this enough. You want to engage service professionals early in the process, right? That's lawyers, accountants, bookkeepers. You want to engage people early in the process to help with all of this, right? It's really important. You want to get down the road when it comes time for investors knocking at your door and you haven't engaged in any of this process, right? You're going to be way behind the curve, right? And I think it's always better that you start early so that when an investor comes, that you're ready and that you're prepared, right? To present to them the best kind of version of your company and of your IP portfolio that you possibly have. So with that, I'm happy to take any questions or comments or concerns that the group may have regarding IP strategy and commercialization. Al, are we turning the mics back on?
So feel free to unmute yourself and turn your camera on, or submit your questions by chat. Looks like we have a question by chat. What is company IP hygiene?
What is company hygiene? All right, let's see if we can go back. I may not be able to find the slide fast enough, but company hygiene is, again, so depending on how you've created your company, right? Maybe it's a limited liability company, maybe it's a corporation. There are certain statutory requirements depending on where you filed that company, right? Whether it's Delaware, Maryland, or some other state, they're required for doing certain things, certain acts of the company, right? How do you amend your articles of organization, let's say, right? Or how do you hold board of directors meetings, right? How do you handle the minutes from those meetings, right? All of those things are important under statute, right? And investors want to see that you follow those statutory requirements, right? A lot of times what happens is that in companies, right, they just make decisions on the fly willy-nilly, right? And forget about that corporate company hygiene that's necessary for it, and then have to go back and ratify certain things that they've already done through a formal process, right? So that's what I mean by company hygiene, right? It's keeping good company records, right? Your articles of organization, any amendments to your articles of organization, any kind of board meetings, okay? And the minutes from those meetings, right? If you have an LLC, make sure that you have a member schedule, right? Which shows the different classes of units and who has what or how many units each person has, right? So again, we could probably spend a lot more time on that, but that's what I mean by corporate hygiene, right? So statutorily, there are certain things that are required for each corporation, each LLC to run. And it's important that you make sure that you follow those statutory guidelines and requirements. Thank you, Hemi, for the question.
Any more questions?